Parol Evidence Rule Part 4, Integration in the UCC. The UCC approach to integration is substantially similar to the restatement approach, although the UCC avoids using the term integration. Under UCC Section 2-202, if the writing is intended as final, that is, integrated, then the terms may not be contradicted by extrinsic evidence. The writing may be supplemented by consistent additional terms unless it is a complete and exclusive statement of the terms of the agreement, that is, a complete integration. In other words, if the writing is only partially integrated, it can be supplemented by consistent additional terms. But if it is a complete integration, then it cannot be supplemented, with 3 exceptions. According to UCC Section 2-202, all integrated agreements may be explained or supplemented The reasoning for allowing these types of evidence is found in Official Comment 2, which says that these types of evidence are part of the background understandings of the parties, and that unless carefully negated, they become part of the contract. The UCC has one final twist. According to Official Comment 3, now this appears to be a variation on Restatement Section 216 subsection 2, where if a term would naturally be omitted, then the court can conclude that the agreement is only partially integrated. 2 points to make about this language. 1, despite that must, it is not part of the statutory language, and so is not binding on a court. And 2, commentators agree that the UCC standard is more willing to admit additional terms. Under the restatement, oral terms come in only if they would naturally have been omitted from the writing, while under the UCC, the oral terms come in unless they would certainly have been included in the writing, in which case they are kept out. Commentators believe that it is more difficult to show that an oral term would certainly have been included in the writing, so it is more likely the oral term will be allowed in under the UCC. To summarize, an unintegrated writing does not present a PER issue. If the writing is completely integrated, the PER applies fully, and extrinsic evidence is not allowed to contradict or to add a new term to the written terms, unless the case involves the sale of goods, in which case course of dealing, usage of trade, or course performance are admissible to supplement, that is, add a term to, the written terms, but not to contradict them. The most complicated situation arises when one party argues that a writing is partially integrated and that there are additional oral terms that don't appear in the writing. The rules for how a judge determines a partial from a complete integration get tricky, and the cases go all over the map. So, in sum, it's a mess.